right, so you're Jonathan Zcaf, and this is 24 DCCR 2348, Mr. Z.
All right, right out of the gate we're seeing the judge confirm identity and case number. This is the foundation of every criminal proceeding. If the courtroom were a movie, this is the opening title card where the stakes quietly drop into place. Jury selection coming up? Yeah, this case was on track for trial until something changed. Let's see what.
Zcaf's case is set for trial also to begin with jury selection on December the 1st. Announcement.
It's pleading to a lesser included.
Oh, it's right here. Gotcha. Hold on. I need to look at too many things. DWI.
Pause. This is where things get interesting. The defense mentions a plea to a lesser included. Translation? The defendant is agreeing to plead guilty to a charge that's lower than the original. This often means the evidence is strong, and both sides want to avoid a full-blown trial. It's like taking the plea deal off-ramp before you hit the trial freeway.
A second, okay. Let me get that pulled up. Mr. Gertz, will your client waive the formal reading of the indictment?
He will, Judge.
All right, Mr. Zcaf, the state has elected to proceed. So it would be on the April 10th, our date, and then just one prior. So it would be paragraph 1 and 2, correct?
Yes.
So it's not really counts. Okay. So the state's elected to proceed on paragraph 1 and 2. It alleges that you committed the offense of driving while intoxicated April 10th of 2024. The indictment further alleges in paragraph 2 that you were...
And here comes the heavy hitter, the prior DWI from 2019. Courts treat priors seriously because they change everything: sentencing ranges, penalties, and probation terms. Notice how the judge confirms each detail? She's making sure there's no wiggle room later if he tries to say he didn't understand. Smart judge.
Previously convicted of driving while intoxicated January 16th of 2019. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty and true freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement is for a 1-year term in the Jefferson County Jail, but that would be probated for 2 years. You would be ordered to pay a $2,500 fine, follow all of the rules and conditions of probation. Also, part of that is that you would serve 10 days upfront time, and you would have the interlock device for that for the first year.
Check out how detailed this part is: fines, probation length, upfront jail time, interlock devices. This is the menu of consequences in a second DWI case. Also, the judge warning that she can extend conditions even if the agreement says otherwise. That's her reminding everyone she holds the real power in this courtroom.
Year of your probation. Is that your understanding? I do want to make sure you understand that conditions of probation are up to me. If for some reason after that year I feel like it would still be necessary for any reason, if there's been any hiccups or anything like that, it could still be ordered by me after that period, regardless of what you guys have agreed to. Do you understand? Okay. State tenders number 1.
We have no objection, Judge.
It's admitted. And sir, are you a U.S. citizen?
Yes,
And is there any evidence that Mr. Zcaf is not competent?
no, Judge.
So are y'all ready? Do I need to get a report? Or
We're ready to proceed, Judge.
All right. So I'm going.
And
Is
then
there?
we have one caveat regarding the upfront time.
That's what I was going to get to. So what's that?
We're asking that the court allow him to do the 10 days on 5 successive weekends, starting on November 28th at 6.
Classic defense move, asking for weekend jail. Why? Because it keeps the defendant employed. Judges often allow this in misdemeanor DWIs when the person isn't considered a flight risk. Smart strategy: protect the job, satisfy the sentence, Keep life from falling apart. Let's see if the judge bites.
6 p.m. it is.
Any issue with that? All right, so I'm going to find that you, again, entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the driving while intoxicated second, a Class A misdemeanor. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail, but I'm going to probate that, and you'll be on probation for 2 years. You're ordered to pay the $2,500 fine and to follow all of the rules and conditions of probation. You will be ordered to serve 10 days up front. That will start on Friday, November the 28th at 6 p.m. And then you will go every weekend until those 10 days, for 5 weekends until those days are served out. It's important that you're on time for that, 6 o'clock. If you're late, it could be a violation of your probation. Do not show up under the influence of anything. Some people think they show up, they're going to do whatever and get there and sleep it off for the weekend. Bad idea. You'll be right back in here on a motion to revoke your probation. You are required to have the auto ignition interlock device for sure for that first year. And then if everything goes fine, obviously that condition would go away as well. If you follow all of the rules and conditions and do everything you're supposed to, then for all practical purposes, your case here in court is over. You'll be able to serve that 1 year sentence while you're out on probation. The other side of that is if you violate any condition of probation, you could be brought back into court and you could be sentenced to that 1 year term that you've already agreed to. Do you understand? Yes, ma'am. I'm going to hand you the trial court certification. Shows that this was an agreement that I followed, and so you've waived your right to appeal. It is a long ways to go from here to there. You need to have a seat once I give you that document here in the courtroom. Probation is sitting at that desk right over there. She's going to call you up when she's ready to go over all of your paperwork. All right, good luck to you, sir. Thank you, Mr. Kurtz and Mr. Smith. Okay, thank you. All right, sir, are you Guillermo Galvin? And Mr. Crenshaw, will your client waive the formal reading of the indictment?
We do, Your Honor.
Let me get that pulled up. I'll take it. I'll take it. Pulling it up the wrong way. So paragraphs 1 and 2 then, to make it a Class A. Okay. Mr. Galvin, in cause number 24, DCCR 2321, the state's elected to proceed on paragraphs 1 and 2 only. Paragraph 1 alleges the offense that we're here for today, that you committed the offense of driving while intoxicated September 28th of 2024. Paragraph 2 alleges that you were previously convicted of driving while intoxicated April 30th of 2014. And how do you plead to that charge?
Yes.
And is that prior conviction true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crenshaw? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for is it a 1 year term, I guess?
Yes, Your Honor.
With everyone's permission, I'll mark that through it. Put that on here. Please, thank you. So it looks like the agreement that you've reached is for a 1 year term in the Jefferson County Correctional Facility, but that would be probated. You'd be on probation for 2 years. You would be ordered to pay a $4,000 fine, serve 1 weekend in jail, and follow all of the other rules and conditions of probation, also including having the auto ignition interlock device and a portable breath device. Is that your understanding?
Yes. Are both necessary while on probation, or can we just do interlock?
We just need one.
Yeah.
Yeah.
He's done well on the portable iPhone, just the interlock, whatever.
I think the interlock is what I would prefer to have. All right, with everyone's permission, I'll mark through that on the paperwork.
Thank you.
So you would be required to have the auto ignition interlock device on any vehicle that you drive. Do you understand? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted any evidence that Mr. Galvin's not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated. Second, sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Correctional Facility, but I will probate that. You'll be on probation for 2 years. You're ordered to pay the $4,000 fine and to follow all of the rules and conditions of probation, including having the auto ignition interlock device on your vehicle. You will serve 1 weekend in jail. That will be the weekend beginning November the 28th. You'll be required to show up at the jail at 6:00 p.m. Don't be late. Don't show up under the influence of anything. Both of those things could be violations of your probation, and you'll be right back in here. Do you understand? If you do everything you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that term while you're out on probation. The other side of that, however, is if you violate any condition of probation, you could be brought back in, and you would be facing that 1-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She will call you up when she's ready to go over your paperwork. All right, good luck to you, sir. Good morning, ma'am. Are you Catherine Jordan? And Mr. Crenshaw, will your client waive the formal reading of the indictment?
We do, Your Honor.
Yeah, staff would be proceeding on the lesser included state jail amount of $2,500 to $30,000 instead of what's declared in the indictment.
That is correct, Judge, and we're also prepared to waive a PSI.
Okay.
Your Honor,
Do y'all?
just for the court's benefit, just really briefly, the defendant has agreed to pay some $24,000 in restitution up front. Mr. Crenshaw has a cashier's check here in that amount for the complaint in this case. There are some other extenuating circumstances that has led the state to enter into this agreement, Judge.
Okay.
And if the court is inclined to waive a PSI, which the state's not opposed to, just in a full candor with the court, Judge, there is some past criminal history, but that has been some time ago, and I'm happy to go into more detail if the court wishes.
If you're okay with it, Mr. Coleman, look, and especially with the fact that the victim will get payment, it looks like upfront.
Yes, sir.
And
It's an
that's in
HOA.
full, correct?
Yes.
And what was that amount?
$24,000 is,
Just to be clear, Judge, it's not the full amount of restitution that was claimed. I think the full amount was in the neighborhood of $36,000. Mr. Crenshaw has provided the state with some mitigating evidence in the form of some receipts that I don't question the veracity of, that would mitigate down the $36,000 figure to $24,000.
Okay, thank you. All right, so will she waive the formal reading of the indictment as modified?
yes, Your Honor.
Ms. Jordan, in cause number 25, DCCR 0440, the state has elected to proceed on the lesser included offense of misappropriation of fiduciary property between the amounts of $2,500 and $30,000. That's a state jail felony again. And that is from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? Speak up, please.
Yes, ma'am.
I have here on the tablet some documents that should have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Crenshaw? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison. That would be probated. You'd be on probation for 5 years. You've agreed to pay restitution, which it looks like is being